Hello, my name is Chad Hansen. I'm a staff attorney with Disability Law Center of Alaska. This is supported decision-making agreements for legal services providers. I'll be discussing what supported decision-making agreements are and what the purpose behind them is. I'll also be discussing some of the tips and tricks for legal service providers and attorneys in Alaska who will be drafting these agreements. Supported decision-making agreements are codified in the Alaska Statutes, Section 13.56. I won't just be reading them out here in this presentation. That's not what this presentation is, but you can read them for yourself, and I would encourage you to do so. It would probably only take you about 10 minutes. They're not extensive, and they're pretty straightforward. But as you can see here, they are fairly new. Supported decision-making agreements have only been in effect since December 26th of 2018. As of this recording, that's a little under 4 months, so there aren't a lot of these agreements yet, and community awareness of what supported decision-making agreements are and how they work is not yet very great. So I think this training will be a good opportunity to help legal service providers be aware of how to draft supported decision-making agreements, but also it might be a good idea for us to come back in a year when there are more supported decision-making agreements actually in effect on the community to see what are some of the problems that we've run into. So what supported decision-making agreements are agreements between a principal, or I like to use the term decision maker because principal is kind of a cold legal term, and a supporter who agrees to assist the decision maker in any area of decision making where the decision maker may need that assistance. The decision maker does still get to make all of the decisions for themselves, but the agreement would allow the supporter to gather information. It would help the decision-making process, and then it would help the decision maker understand that information and come to an informed decision. The main thing here that we like to stress is that the supporter does not get to make the decisions on behalf of the person they are supporting. It's not a substitute decision-making process. It's a supported decision-making process. So why do we need this? Guardianships already exist. That's a way to help with the decision-making problems with people who are suffering capacity issues. Why do we have supported decision-making agreements? Supported decision-making agreements help empower people living with mental illness or developmental disability to live in a way that keeps them integrated in the community and helps them exercise their own self-determination. Part of this is that allowing people to make their own decisions about where they live, where they work, medical care, etc. It's a less restrictive approach to traditional things like guardianships, and it allows the decision-making power to be retained in the individual rather than given to another person to make those decisions on behalf of the decision maker. So with that in mind, this might be a little bit of review, but we put together the Continuum of Decision-Making. Most people are familiar with what a guardianship is. A guardian is appointed by the court, so there is court oversight, and they have at least some, and usually close to all of the important decision-making power on behalf of the person that they have guardianship over. Power of attorney is a little bit less restrictive. You retain your own decision-making power, but you also grant it to somebody else. So if you entered into a lease agreement and the person with your power of attorney also entered into a lease agreement, both of those are valid agreements. And then a representative payee is just somebody who gets to make decisions about how money is used when somebody receives public benefits from Social Security. So a supported decision-making agreement is a less restrictive alternative to those three other decision-making options, and it allows the person to retain their decision-making authority, as we said, but also receive that community support in helping receive the information and understanding what it means so that they can make that decision. It's kind of like a formalization of relationships that the person might already have. And you see that arrow at the bottom leading from more restrictive to less restrictive. If we were to reverse that, it says a more gradual transition as decision-making abilities decrease. So one of the ways that a supported decision-making agreement could be used would be for somebody who is aging and maybe they're not as able to be as independent as they once were, but guardianship is not quite appropriate for them, and in fact they lose a lot of their independence and their life skills by going from full independence to a guardianship. So a supported decision-making agreement might be a good step down in that process, even if one day they may eventually need a full guardianship. So who can have a supported decision-making agreement? The legal requirements for a decision maker to enter into a supported decision-making agreement, there's not a ton of them. The person needs to be an adult. They need to enter into the agreement voluntarily, so there can't be any coercion or undue influence to get the decision maker to enter the agreement. And they also need to understand the nature and effect of the agreement. So that's one thing that might be at issue. You want to know, does the person have the capacity to understand the agreement's purpose and what that agreement is allowing them and their supporters to do. Another thing to keep in mind is that a person can have both a supported decision-making agreement but also have a guardian or conservator. It's just that the guardian or conservator needs to approve the supported decision-making agreement in writing. And so one thing you want to keep in mind as you're drafting these agreements for people, or as you're talking to people who are interested in supported decision-making agreements, is that if they have a guardian, you want to find that information out. You also want to discuss it with the guardian. And, sometimes the guardian might actually be your main point of contact. You want to make sure that the decision maker is involved. But lots of the conversations that I've had with regards to supported decision making has been a guardian saying, I have a guardianship over my son or daughter, and I would like them to not need the guardianship or for them to be more independent when I'm gone. And so I think setting up a supported decision-making agreement now and letting them have that support and grow with it would be a good way to maybe releasing the guardianship down the road. So anyone who meets those requirements that I just discussed can have a supported decision-making agreement. You don't have to be under threat of a guardianship. You don't have to be in advancing age. There doesn't have to be really a reason for you to want a supported decision-making agreement. And one thing to keep in mind that people might be worried about is that having a supported decision-making agreement cannot be used against the person in a guardianship hearing. There's nothing in the statute that says that it can't be used in support of releasing the guardianship, but the statute itself contemplates not using the supported decision-making agreement to doubt somebody's capacity. And in fact, a decision-maker is presumed to have capacity, even if the decision-making assistance from the supported decision-making agreement is what helps the decision-maker reach capacity. So on the other end, who can be a supporter? The decision-maker should identify somebody, or maybe multiple someones, that they trust to gather that information and provide them with advice. Lots of times it's relationships that we already have. Maybe these people already fulfill this purpose for us in helping us understand information, gather that information. It's just a formalization of those relationships into a document. But the legal requirements for a supporter is that they must also be an adult. They cannot be an employer or an employee of the decision maker unless they are also a family member. And so one way that this might come up is that a business owner may want their executive assistant to have a decision-making agreement with them. So that way it's just faster for them to be able to get information that might be confidential and just help in the business process. That's one of the ways that this agreement wouldn't be allowed unless that person was a family member. And it cannot be somebody who provides paid support services unless, again, that person is also a family member. One thing I do want you to think about, though, as these are Alaska-specific statutes, is that we do have a lot of small communities in which people know everybody and in which people may be wearing multiple hats. You may go see a medical service provider. That person might also be your friend outside of that position. I personally don't think that there would be a problem with having an agreement that says this person is going to help me with regards to looking for employment and looking for a place to live. But because they are a medical service provider, they will not be assisting me in where I seek my medical services because they have a vested interest in that. One thing I would want to be sure, though, if you go down that route, is that you have that conversation with the supported person, you have that conversation with the guardian, if there is one, and you have that conversation with the supporter as well, saying, hey, you can help with these specific things, but it would be out of line for you to be a supporter in the medical services arena. And then if everybody is on board with that, you also want to formalize it in the document. When you have the supporter themselves, you want to make a note saying this person will help in these arenas, but because this person is involved in providing XYZ, they will not be a supported person for this purpose. I think that would obviate the problem with the paid support services prohibition. And then if down the road somebody were looking at this document and to say, hey, I have a problem with this person being your supporter, you can point to that note in the supported decision-making agreement and say, this is something that was contemplated when we drafted the agreement. We're aware of it, and we took steps to make sure that there wasn't any undue influence there. Another thing to be aware of is that who's likely to be the person who would challenge a supported decision-making agreement. It's likely to be the guardian, probably, the decision maker, or that supporter. So if you've had conversations with those three people and they feel like that problem with paid support services has been obviated because that person won't be helping in that arena, then that's something that you plan for. And it also helps with the problem of limiting options in small communities where you may only know a few people who have multiple hats. The final legal requirement for somebody to be a supporter should be an obvious one, but there cannot be a protective order or restraining order in place between the supporter and the decision maker that keeps them apart or keeps them from contacting each other. It's kind of hard to provide those support services if you cannot be in contact with each other, and in fact there's a court order saying don't do that. So once these legal requirements have been met, anyone can be a supporter. So what's the actual authority of the supporter then? This isn't the statutory language, but the statutory language does boil down to four short things. That person can gather information. They can help the decision maker understand that information. They can learn what the decision maker ultimately decides, and they can communicate that decision to the necessary third parties. So it's not a supporter's place to make the final decision for the decision maker. They're not substituting their own judgment for the decision makers, but they are there to assist in that process. They can explain pros and cons. They can help weighing what the information is, but it's not their final say. The supporter is limited by the scope of the agreement, so that kind of goes into my previous example with the medical service provider, but it means that if an agreement provides that somebody will help with living arrangement decisions only, the supporter should not be out gathering medical records or job applications because that's not relevant to the scope of the agreement. And finally, supporters cannot make financial transactions for the decision maker. I would interpret that to mean that merely running an errand to deliver a signed check that the decision maker had signed is probably fine. Taking the decision maker's credit card and using it with a third party is probably not fine unless the decision maker is present. What is the scope of supported decision-making agreements? So there are many different areas that the statute contemplates where a person may want help gathering information, and there's even kind of a catch-all provision that will allow you to add other areas where somebody might want that help. But some of the main ones are obtaining food, clothing, or shelter, taking care of physical or mental health, managing financial affairs, obtaining education or training, choosing and maintaining supports and services, or finding a job. When I talk to people, I try to be as specific with them about the area where a person wants that help rather than general, so that way somebody looking at the document wouldn't see much ambiguity about how far the supporter's authority extends. Now, you may have conversations with decision makers or prospective decision makers that say, this is my friend, I trust him implicitly, I want him to help me in every area of life, and I want every single box checked, and that's fine, but you want to make sure that you've had that conversation with the person so that what you're putting into the agreement accurately reflects their wish for that agreement. This question comes up a lot as well. What if a supporter commits abuse? There's not any court oversight of a supported decision-making agreement like there are for guardianships. Guardianships are subject to periodic guardianship reviews, but supported decision-making agreements don't even come before a court. There's not any oversight there. How do we protect these people? It's a question I've heard. It's a question that's come up in other jurisdictions that have supported decision-making agreements. One thing to keep in mind is that there are laws protecting people from fraud, exploitation, and abuse, and those apply to supported decision-making agreements. And supported decision-making agreements are also contracts, so they're subject to any contractual protections that might apply. The supported decision-making agreement statutes themselves expressly prohibit the supporter from exhibiting undue influence or making the decision themselves or obtaining information that's not related to the supported decision-making agreement. And they can't use any of that information on behalf of the decision maker for unauthorized purposes. Another thing to keep in mind is that either party may terminate the agreement at any time. So if a decision maker feels like they're being taken advantage of, they're free to say, I do not want this person to be my supporter. And we'll discuss in a few minutes how to terminate a supported decision-making agreement or alter it. But either party is free to terminate that agreement and that formalized relationship at any time. So what does a supported decision-making agreement look like? Well, luckily, the statutes provide a template for how the agreement should look. That can be found at 13.56.180. It does say that a supported decision-making agreement must be in substantially the following form, so they don't just suggest a template, they say, here, it should more or less look like this. However, some modifications may be necessary. You'll see the picture on the right there is page 1 of the template that I created for Disability Law Center. And in the course of creating these agreements, I did find it necessary to make some modifications. One example was with notaries. At the end of the agreement, there was one spot for a notary to stamp and sign. However, if you have multiple supporters identified and they're not all available at the same time to go and meet with the notary's not going to stamp it for somebody else to be able to affix their signature to the document later if they're not there. So I just modified the agreement so that it would have multiple spots for notaries under each supporter so that, if necessary, the agreement can be done piecemeal. Additionally, the statute only has room for 3 supporters and says that another document can be made to be attached for additional supporters. I didn't make an additional document. Instead, I just modified the document to include multiple supporters. I don't think that substantially alters the template. In fact, I think it makes it probably easier to read for third parties. You can see in this picture again to the right that there's a box highlighted there that says supporter 1 address. What I did to kind of make sure that that this process stays in substantially the same form as the statute is I made it a document that was form fillable only. So I can only edit specific parts of that document. I can edit the decision maker's name, I can check boxes, I can check things and write things that are specific to that person, but I'm not going to be editing any of that language that is the same for every single person I'm going to write an agreement for. And I think that just makes it easier to have documents that look the same and that look like the statute. That being said, if I do need to edit the document, like adding in spots for new supporters or other supporters, I can make it an editable document and do that, but I like to keep it in this form fillable type format, and it just kind of harmonizes it with the statute. So I mentioned earlier working with guardians, and the statute does contemplate that when the principal has a guardian or conservator, they need to be notified of the agreement, and they also need to sign off on that agreement in writing, and there's a spot on the form that it's a checkbox saying that they will attach a statement saying that they're aware of the agreement and they support it. I make it a practice to work with both the decision maker and the guardian when I'm writing a supported decision-making agreement. Again, it might be that the guardian is your point of contact. It might be that the decision maker is your point of contact. But ultimately, you're trying to identify what the decision maker wants. And you also want to make sure that the guardian will accept the final supported decision-making agreement. So having a conversation with the decision maker that identifies what they want, that they do in fact want a supported decision-making agreement, and that they do want these people to be their supporters is important, even if you're primarily working with the guardian. On the other hand, if you're working primarily with the decision maker, the guardian's required to sign off on the agreement itself. So you want to have a conversation with them and know that you're not doing this for no purpose. In fact, you're doing this because the guardian either supports or wants the decision maker to have this agreement. Another thing that's come up for us as we've been working on these agreements is how supported decision-making agreements are recognized in the community and how they're actually supposed to work in the real world. Because of the newness of supported decision-making agreements, people that the supporter may interact with, third parties, will not know what a supported decision-making agreement is, and they may not know why they should accept them. They might be worried about getting into trouble if they act in reliance on those documents. So there is statutory authority that supported decision-making agreements should be accepted. That's posted there, 13.56.130. And 13.56.140, the very next statute, limits the liability of those who act in good faith in reliance on the agreement. One thing that should prevent this as being a problem is that the supported decision-making agreement should be accompanied by a release of information anyway. So a medical provider should be willing to talk to a supporter if they are provided with a release of information. Again, it's just a formalization of an existing relationship. But I've heard that sometimes somebody presented with a supported decision-making agreement might say, no, I don't understand this. I understand guardianships, I understand powers of attorney, but I don't know what this document is. So one thing that we're looking into doing is drafting a letter that includes language from both of these statutes that will go with the agreement and that the decision maker can make copies of, that just says, this is what a supported decision-making agreement is. This is why it should be accepted. And more importantly, this is why you won't get into trouble for working with the person who presents you with this agreement. And it would probably just be a one-pager that you can write up and provide to the decision maker at the time that you provide them with the agreement. Finally, terminating or modifying a supported decision-making agreement. I posted the statute there, but either party can terminate the agreement at any time, and that termination should be signed and in writing, and notification to the other party is required. So a supporter who decides, this is maybe a little bit more than I had in mind when I signed this agreement, I don't want to do it anymore, can't just leave the decision maker high and dry. They need to notify that person. They can do that face-to-face. They can do that through certified mail. They can do that through an email. And all of that is codified there in the statute. And finally, partial terminations are okay. So if I have 5 supporters and supporter number 3 tells me they don't really want to be my supporter anymore, then the other 4 supporters are all still my supporters. The entire agreement isn't void. It's just that one person who has revoked their part of the supported decision-making agreement. However, to be clean, if a decision maker contacted me and said, you know, you wrote the supported decision-making agreement for me, since that time, 1 or 2 of my supporters have decided that they don't want to be supporters anymore, and I've identified maybe somebody else who could be a supporter, I would probably just create a new agreement, and I would probably just add a little addendum to that agreement saying that this entire agreement replaces the previous agreement that was entered into on whatever date. And I think that would just be easier to keep track of. It would also be cleaner for people, third parties, trying to read that document. So that's the presentation. Hopefully it's been helpful in understanding what supported decision-making agreements are, what to look out for when you're drafting them, and then what the ultimate draft should look like. It's not that difficult, but as I mentioned at the beginning of this presentation, it would probably be good for us to do another one of these videos in about a year when there are more agreements out there in the wild. We can see how they're being responded to, and we can kind of run with what's working in the community and what the challenges are on the ground. As of now, Disability Law Center Alaska has entered into a partnership with Hope Community Resources to provide supported decision-making agreements to members of the disability community. How that's currently working is that prospective decision makers are working with Hope to go through kind of the social work aspect of it. They sit down, they have a conversation about, I want an agreement, here's who I think my supporters should be, here's the areas I think that I need support, and Hope kind of harmonizes that into a narrative that they provide to us at Disability Law Center so that an attorney can draft the agreement itself, and they would work with the decision maker as well as the guardian if there is one. I've included contact information for both here on the slide, and as Disability Law Center is drafting these agreements currently, you can reach out to us at that ocpa@dlcak.org email address with questions if you have any as you're drafting these agreements, and they will be funneled to a person who can hopefully respond and answer your question. I hope this video has been informative, and I hope it helps you as you draft your own supported decision-making agreements for Alaskans.